Hello everyone, I am Dr. Veena M.D Almeida, Associate Professor, Department of Commerce, Teresian College, Mysore. Today's subject of discussion is Company Law and Practice, Unit Company Meetings. In this particular session, we are going to discuss about agenda of a valid meeting, motions and proposals, sense of the meeting, resolutions to be passed at the meeting, minutes of the company meetings. Agenda of the meeting. The term agenda literally means things to be done in relation to the meetings of a company. It means the program of business or the list of the items of business to be transacted at a meeting. Importance of agenda. The preparation of agenda is considered necessary for the conduct of the business of the meeting systematically without any confusion and without any omission of any items of importance. Further, it contributes to the conduct of the business of the meeting quickly without loss of time. Again, the agenda sent to the members enables the members to come prepared for the meeting. It is because of the importance of agenda that though the Companies Act does not make it obligatory on a company to send an agenda or to incorporate it in the notice of the meeting, every company sends the agenda or includes it in the notice of the meeting sent to every person entitled to attend the meeting. The agenda is generally prepared by the secretary of the company in consultation with the chairman of the company. After the agenda is prepared, a copy of the agenda is sent to every person entitled to attend the meeting. Alternatively, the agenda is included in the notice of the meeting itself. The agenda or the notice containing the agenda is generally sent to members sufficiently in advance so as to enable them to come prepared for the meeting. This is the format of the agenda of a meeting, which includes company name, address, which type of meeting, name of the chairman, who is recording the minutes, date, time, location, items to be discussed at the meeting, etc. The business of a meeting is transacted through motions or definite proposals. A motion is a definite proposition or proposal placed before a meeting for discussion and decision. The articles of every company usually lay down the rules governing a motion. The essentials of a motion are: a motion must be in writing, it must be signed by the mover, it should be drafted in clear, definite, and unambiguous terms. It should be in an affirmative form. A negative motion is desired only when the meeting wants to avoid certain events. The articles of every company usually require previous notice of a motion before it is brought up before the meeting so that it could be included in the agenda. A motion should be within the scope of the business of the meeting. A motion should be commenced with the word that, so that when it is passed into a resolution, it could run as resolved that. A motion must be formally moved by a person at the meeting and must be seconded by another person. Ordinarily, a motion once proposed and seconded cannot be arbitrarily withdrawn by the mover. It can be withdrawn at the discussion stage by the mover only if the seconder agrees to it and the meeting also gives its consent. Once a motion is duly proposed and seconded, the chairman of the meeting invites a debate or discussion of the motion. During the discussion, every member is entitled to speak on a particular motion only once. He cannot speak on the same motion for the second time. This restriction is placed with a view to keeping the deliberations within limits. Of course, the chairman has discretionary powers to relax this restriction when necessary. After the debate or discussion on the motion is completed, it is put to voting, and if it is passed, it becomes a resolution. Ascertaining the views or opinions of the members on the matters under discussion is known as ascertaining the sense of the meeting. The sense of the meeting is ascertained by the chairman of the meeting by putting the question or proposal before the meeting to vote. The important methods of voting that are adopted in company meetings for ascertaining the sense of the meeting are voting by show of hands and voting by poll. Under voting by show of hands method, the members present in a meeting indicate their opinion or views on the motion by raising their hands in turn. After comparing the total number of hands raised in favor of the motion and the total number of hands raised against the motion, the chairman declares the result on the basis of the majority of the votes. In case the number of hands raised in favor of the motion is equal to the number of hands raised against the motion, the chairman can exercise his casting vote if he is entitled to a casting vote and announce the result. And the second important method is voting by poll. Under this method, the members present in a meeting, either in person or by proxy, express their views by casting votes either in favor of the motion or against the motion. The number of votes cast in favor of a motion and the number of votes cast against the motion are compared, and the decision is taken on the basis of the majority of the votes. It is true that under this method also decision is taken on the basis of the majority of the votes, but under this method the voting rights of the members is in proportion to the number of shares held by them. Further, under this method, not only the members present in a meeting in person, but also the members present in a meeting by proxy can exercise votes. Business is transacted at a general meeting by passing resolutions. So it is better to have some idea about resolutions. When a motion is passed in a meeting, it becomes a resolution. So, a resolution may be defined as the formal expression of the decision of a meeting on any motion or proposal before it. In other words, it is the recorded decision of the meeting. In short, it is the decision of a meeting on a motion. The essentials of a resolution are: a resolution should be in writing. Every resolution passed at a general meeting of shareholders must be recorded in the shareholders' minute book, and every resolution passed at a board meeting must be recorded in the directors' minute book. Every resolution must be recorded word by word. A resolution passed at a meeting cannot be annulled or revoked at the same meeting. However, it may be revoked at a subsequent meeting if a motion for the revocation is brought before a meeting specially called for the purpose and is carried by two-thirds majority of votes. As per the Companies Act, three types of resolutions can be passed by the shareholders at the general body meetings. They are ordinary resolutions, special resolutions, and resolutions requiring a special notice. Ordinary resolution. As per section 189, subsection 1 of the Companies Act, an ordinary resolution is one which is passed by a simple majority of votes of members present in person or by proxy at a properly constituted and convened general meeting. According to the Companies Act of 1956, an ordinary resolution is passed to transact the businesses like to approve annual accounts and auditor's report, to adopt the director's report, to declare dividend, to appoint directors, to create reserve fund, to issue bonus shares, etc. Special resolution. According to Section 189, Subsection 2 of the Companies Act, a special resolution is one which is passed by at least three-fourth majority of votes of members present in person or proxy at a properly constituted and convened general meeting, and the intention to propose the resolution as a special resolution has been duly specified in the notice of the meeting given to all the members entitled to attend and vote at the meeting. As per the Companies Act, a special resolution is required for transacting businesses like to change the name of the company, to change the registered office of the company from one city, town or village to another city, town or village in the same state, to change the registered office of the company from one state to another, to change the objects of the company, to alter the articles of association of the company, etc. Third category, resolution requiring special notice. A resolution requiring a special notice is one for the moving of which a special notice is required to be given by the mover, indicating his intention to move the resolution to the company at least 14 days before the meeting, and the company in turn is required to give a notice of the resolution to all the members entitled to attend and vote at the meeting at least 7 days before the meeting. The articles of a company may specify the purposes for which special notice is required. They are to appoint an auditor other than the retiring auditor, to provide that the retiring auditor shall not be reappointed, to remove a director before the expiry of his term of office, and so on. This is the format of the resolution passed at the Board of Directors meeting. Section 193 of the Companies Act provides that every company must keep minutes containing a fair and correct summary of the proceedings of general meetings, board meetings, and meetings of the committees of the Board of Directors. So it is better to have some idea about minutes of meetings. Literally, minutes refer to a note to preserve the memory of anything. So, the minutes of a meeting are the written record of the business transacted and decisions arrived at a meeting. In other words, they are a concise and accurate official record of the proceedings of and the decisions reached at a meeting. The minutes of the meeting must be written within 30 days of the conclusion of the meeting. The minutes of the meeting must be signed by the chairman. The minutes of the meeting are written up by the secretary with the help of the notes of the proceedings of the meeting taken by him and the chairman during the meeting. Remaining provisions of the Companies Act relating to company meetings are discussed in the coming sessions. Thank you.